Okay, we're gonna start this case. It's Zabarik versus the Valley View Park Estates Homeowners Association, DC 234045. Council, make your appearances.
Good morning, Your Honor. I'm Bo Powell here for the plaintiff.
Catherine Stark for defendant.
Okay, you guys go ahead and make your argument.
Judge, it's a motion to quash, and we're simply here asking for a order compelling defendant to produce a corporate.
Isn't this Ms. Stark's? This is Ms. Stark's motion, isn't it?
Yes, Judge.
Yeah, go ahead and let her start.
We filed this motion to quash because this is the first time we had heard anything about plaintiffs wanting to take the deposition of anyone. They noticed the deposition unilaterally without conferring, Judge, and they have just failed to confer pursuant to the local rules on many issues in this case. And this is just another example. We didn't have any chance to agree to the time and date of the deposition. They also didn't identify anyone in particular, and we're still in the process of trying to identify the person who can testify on all of these issues. Judge, 30 topics they would like to discuss or have the witness testify upon at the deposition, and none of these topics were conferred upon, and we do not know yet at this time who would be the person best able to talk about this, or the person with most knowledge. And that is in contravention to the rules, specifically Rule 192.6 or 199.2 B1, which requires that the deposition notice of a corporate representative must describe with reasonable particularity the matters on which the examination is requested. And that was noted in our motion to quash. But also, the defendant has a right to identify and present who they would like to testify on these issues. And so it's not proper for a plaintiff to demand the person with the most knowledge or the person who's most knowledgeable, because that's not what the rules contemplate. Again, defendant has a right to select the person who can best represent the company to testify about the specified topics. And that's not always the same person who might have the most knowledge. And that's part of defendant's strategy, which is something that we are entitled to control and prepare for trial. And also, the HOA is run by volunteers, and all these people have their own careers and their own families. So again, this deposition was unilaterally noticed, and we just don't have, we didn't have any opportunity to coordinate availability with particular members of the HOA who are unknown at this time, as we're still going through all these 30 separate topics. And they have their own procedure with dealing with litigation and presenting themselves for depositions. So there's no reason to compel this deposition when we have not even been given a chance to confer on who's going to be deposed, the time of the deposition, the topics of the deposition.
Okay. Mr. Powell?
Thank you, Judge. The court probably recalls as this case is no stranger to the court, and these parties are no stranger to one another. I am pinch hitting this hearing for Mr. Welch, but the first thing I want to say to the court is that I'd bet my boots we made numerous efforts to get deposition dates from the defense before we noticed the deposition. I've been at this office going on 7 years, and that's the way we do it. We don't haul off and send deposition notices on our own without ever asking for a date first. On this whole conference issue, the court will notice in the motion to quash, it's a quash filed based on an alleged unavailability. There's no alternative dates offered. There's no alternative times offered. to sum up the whole argument as put by Ms. Stark, this is all strategy. They're trying to evade discovery any way they can. So we're here today asking for an order from the court that the defense produce a corporate representative or representatives to testify on those topics within a reasonable time, whatever the court determines that may be, 30 days, 45 days, whatever. All the rest of the arguments are, quite frankly, without merit. Judge, if the court looks at the deposition notice, there's 30 topics there. Those are all very specific topics. All those topics tie back to the second amended pleading that the plaintiff filed following a hearing on the defendant's special exceptions. There's no games going on here, Judge. In our second amended petition, we set forth 8 or 9 different ways we claim that the HOA is violating fiduciary duties, and each of the 30 topics in the notice specifically relates to one or more of those breaches that we've identified in the pleading. I don't have to identify corporate representative. That's the defendant's job when I send my topics. So I think that covers the whole argument. The topics are reasonably specific. They all tie back to the amended pleading. There's no question what's going on here. There's no question of what the claims are. These parties are no strangers. And again, we're simply seeking a corporate representative deposition, and unfortunately, we've got to come to the court to even get the defense to offer us a date on which we can take that deposition or depositions.
So Ms. Stark, is there anything specific in the 30 requests they have that you feel like is unnecessarily broad or not clear?
Yeah, and I also, if I can respond to some other points
That's my question right now. So respond to that question, please.
For example, if they ask for someone with the most knowledge of all bylaws, regulations, covenants and restrictions of the HOA.
So here's a copy of the order they're proposing.
Okay.
So your issue is really just with the term most as opposed to knowledge, I guess, or what exactly is your objection here with the?
Right. Well, the problem is they're seeking someone with the most knowledge of each of these issues, and that may not be the person that the defendants choose to present as a witness.
So you prefer it to say just knowledge as opposed to most knowledge? I've never heard this argument before, so I'm kind of not sure where you're going with that.
Yes, just because the person speak on behalf of defendant, and whoever the defendants decide is the best to represent the corporation and goes along with the strategy that we decide, it might not be the person with the most knowledge. And also, the requests are just really broad. The person with the most knowledge of attorney's fees expended in litigation. Person with the most knowledge of methods and procedures used to maintain and repair common areas. Each of them are very non-specific.
Let's see. All right, let's go to O'Connor's. 6F. It'll probably talk about this most knowledge thing. Where in the rules do you, and I'm not questioning, but where in the rules does it say that it has to be knowledge as opposed to most knowledge?
I don't have that particular rule in front of me right now, but I think it has to do with 199.2B or 199.2. Additionally, as one of the cases I cited in our motion to quash, a lot of these requests are overly broad and just not reasonably calculated to lead to admissible evidence. Kind of like their petition, it's very broad, and looking at all of these topics, you can't really ascertain what they're seeking to depose our witness on, other than just everything about the way the HOA operates. And that's Rule 192.3. These topics are overbroad.
Judge, I challenge her to pull a topic out of this notice that does not relate to one of those 9 issues in the amended pleading. They can't do it. That's why it's not in the motion.
I mean, I just specifically referred to numerous topics in here that are just overbroad, and you can't look at this and know what they're trying to depose our witness on. It's just everything about the way the HOA operates. Like, for example, services, maintenance, capital improvements in the last 5 years. Well, what kind of services, what kind of maintenance, what kind of capital improvements, what kind of contracts?
Judge, these are exactly, this is, and I know the court knows this is why you object to the topics, but you still put a witness up for the deposition. You don't force the parties to sit around waiting on dates. You don't give dates so a party notices. Then you improperly quash. You don't provide alternate dates. You force everybody to wait a month and have a hearing. You waste the court's time only to eventually put up a witness, when all you got to do is put up a witness, object to the topic, and if it can't be resolved during the deposition, maybe then you get the court involved. But all this idea of, well, that's not the person with the most knowledge, we're only giving you somebody with knowledge. All we're looking for is the very first deposition to be taken in this case to perform basic initial discovery, Judge.
Judge, if I could please respond. Counsel said that they asked for deposition dates. They have not presented any copies of emails showing that they did that. I don't see anywhere that they have ever requested any depositions. And Judge, we did in fact respond to their notice of deposition and agreed to present a witness at a mutually agreed upon time and date, and said that we would offer our corporate witness when we identified the.
So let's just get this done, because I don't want you, I've already dealt with y'all in previous litigation. There's going to be a lot of hearings. So what dates do you have available to give this deposition?
I don't have specific dates right now because we still don't know who we are presenting to address these 30 separate topics that are very broad. So that's causing a bit of delay, but I assume it'll be, sometime before the end of the year, ideally.
All right. So I have to kind of agree with the plaintiffs. We're going to require the deposition to take place. Mr. Powell, that you're covering for somebody. Ms. Stark, is this your case or are you covering for somebody?
Yeah, I am co-counsel on this case with another attorney at my firm.
Okay, so Mr. Powell, do you even have Mr. Welch's calendar to be able to schedule a deposition?
No, and I'm not trying to put Ms. Stark in a bad position. That's why I say, I think if the court just says within the next 45 days or something like that, then I'm sure everybody can come to an agreement on one date over the next 45 that works for everyone.
Okay.
We just have a problem with the 30 separate requests that are overbroad. It's difficult for us to identify who would be a good witness to testify as to these topics because they're so broad. And as I said, you can't look at the requests and anticipate really what they're trying to get at. It's just kind of all encompassing about the HOA's operations, procedures, regulations, bylaws.
I'm going to order the deposition to take place by November. When is y'all's trial setting on this case?
got a notice of trial. I think it's sometime in April of next year.
Okay,
Yeah, that sounds right. We got a mediation order by March 30th, so it's obviously after that.
all right, so we are, I'm gonna order the deposition to take place by November 10th. And not sure about this whole most knowledge argument. I've never really heard him make that argument. Let's try to keep this focused, Mr. Powell, on the issues in this case. There has been a lot of issues in the past. Ms. Stark, if it turns out they're going into a lot of issues that are not related to the case, then feel free to call me during the deposition so I can rule on that. Since there weren't any objections filed to the particular topics, I'm not going to rule on each of them piecemeal. So they just, all questions have to be related to the case, I guess is really what I'm getting at. So I'm going to go ahead and grant, or I guess deny the motion and order the deposition to take place by November 10th.
Understood. Thank you, Your Honor.
Anything else, guys?
Nothing from me.
No,
All right. You guys have a great rest of your day, okay?
thank
You
you.
too. Thank you, Your Honor. Bye, y'all.